Everyone who drives a car in New York needs this specific type of insurance coverage. Not having it could have devastating consequences if you're in a car accident. The cost of obtaining it is nominal compared to the benefit it provides. It's called Supplemental Uninsured Underinsured Motorist Coverage, or SUM for short. And what it does is it gives you the ability to protect yourself from someone else's negligence. My name is Rizzuto from the Rizzuto Injury Firm. We represent individuals injured in car accidents all over Long Island, throughout all 5 boroughs of New York City, Westchester, and beyond. In this video, I'm going to explain to you one of the most unknown, misunderstood, and unexplained benefits available to you from your own insurance company. And like I said, the cost of obtaining it compared to the benefit it provides is nominal for the tremendous benefits some coverage could provide you. In New York, supplemental uninsured, underinsured motorist coverage is optional. You don't have to take it. But the reality is most people don't even know it's available or that it exists. But it is so important. Why? Because it protects you if you're in an accident with another vehicle that has no insurance or not enough insurance to cover you for the injuries you sustained as a result of their negligence. It is an extra layer of protection for you because in New York State, you will be shocked to know that the minimum amount of insurance that anyone operating a motor vehicle is required to have under the law is, are you ready? $25,000. $25,000 is the minimum amount of insurance that New York State requires every operator to have if they are operating a vehicle in the state. Quite frankly, it is sickening at how many drivers in the state operate with the minimal amount of insurance coverage. And I understand insurance is expensive, and I understand the rates are consistently going up, and not everybody can afford more insurance coverage. But the reality is that if you are in an accident with somebody who has $25,000 in coverage, and you have catastrophic injuries, and you do not have SUM coverage, the most you will recover is $25,000. So you have the ability to protect yourself in the event that you are in an accident with another vehicle that does not have sufficient coverage or any coverage at all. And you can imagine on Long Island, in New York City, in Westchester, and most of New York State, how congested it is and how many vehicles are on the road. The likelihood of getting into an accident is very high. We get hundreds of cases coming through this firm every year with people who are injured as a result of car accidents. And unfortunately, I have had too many situations where the adverse vehicle who we are suing only has $25,000 in coverage. Now, in every injury lawsuit, there need to be 3 elements in order to be successful. There needs to be negligence or liability, which means somebody has to be at fault for causing the accident. Number 2, there have to be injuries caused by the accident. And if it's a car accident, you have to sustain a serious injury as defined under the New York State insurance law. Third factor, in order to be successful in any injury case in New York State, is you need a deep pocket. Usually that's the insurance company. So if a car has the minimum coverage of only $25,000, you don't have that third element. But the state and your insurance company gives you the ability to protect yourself by purchasing this supplemental uninsured, underinsured motorist coverage SUM. Now, this coverage doesn't only protect you if you're driving a car. It protects you if you're a passenger in somebody else's car. It protects you if you're a pedestrian. It protects you if you're a bicyclist. It protects you if you're riding a motorcycle. You do not have to be operating a vehicle in order to get the benefit of this coverage if you have it. If you or someone in your household has this coverage on their policy, you can reap the benefits if you need it. So how do you make an SUM claim? First thing you need to know is that you are actually making the claim against your insurance policy, because that is the coverage that you have bought to protect you if you're in this situation. Many clients of mine have expressed concern about making a claim against their own insurance company because they are very fearful that their rates might go up. That is one of the biggest concerns that they have when they are faced with this situation. My answer to that is very simple and very basic. You're purchasing the coverage for a reason. You're purchasing it in the event you're in this situation where you have injuries that are worth more than the insurance coverage available to you by the vehicle that caused your injuries. So you're purchasing it for this specific reason. Why are you paying for this coverage if you're not going to use it? The other thing you need to take into consideration is even if your rates go up, and they should not go up just because you are a victim and you are availing yourself of the benefits you purchased and are paying for. They should not go up. But let's say they do. Let's say the insurance company comes up with some reason, such as it's an annual increase anyway, and we're increasing rates. Your rates are not going to go up as much as the benefit you will receive by pursuing this claim. Now that we're making this claim, you need to know the maximum you can recover is the greater of the sum coverage that you have purchased or what the adverse vehicle has. Now, if the adverse vehicle has greater than the sum coverage that you have purchased, you're never going to make a claim under your sum policy. But if the other vehicle has less, the most you can receive combined is what you have purchased in sum coverage. So if you're in an accident and you have injuries that are worth $200,000 and the other vehicle only has $25,000 in coverage, and you only have $100,000 in sum coverage, the most you will get is $100,000 because your insurance company, the sum carrier, gets the benefit of an offset of what the other vehicle has. Another important fact you need to know is you cannot purchase more SUM coverage than you have in bodily injury coverage. So if your policy limits are $100,000, you can only purchase $100,000 in sum coverage. If you have a $25,000 policy, you can only purchase $25,000 in SUM benefits. But I tell people all the time is you really need to increase your policy limits, because having $25,000 in SUM coverage only protects you in the event you are involved with a vehicle that has no insurance at all. Otherwise, if you're involved with a vehicle that only has $25,000 and you only have $25,000 in SUM coverage, you don't get the benefit of your coverage because your company gets to offset the claim from the other vehicle, which is $25,000. Now, before you can file a sum claim, you need three things. You need a letter from the adverse insurance company tendering the policy limits of the adverse vehicle. Number two, you need a confirmation of the policy limits of the adverse vehicle. And number three, you need what's called an affidavit of no excess. That is an affidavit from the adverse driver and owner of the vehicle that caused your accident and caused your injuries, stating they have no additional insurance coverage available. Now, once you have those three things, a letter needs to be sent to your insurance company, sending those three documents to them, requesting permission to settle the underlying claim and to pursue the SUM claim. If your insurance company does not respond to that request in writing within 30 days, their consent is implied and you can pursue the SUM claim, but you better have proof that you sent the letter requesting permission to settle the claim. And you can settle the underlying claim and then file a demand for arbitration for the SUM claim. I've also seen one time where the insurance company denied consent to settle the claim, and basically the insurance company insisted that the case be litigated, and they litigated it because they believed that the defendant or the person who caused the accident had assets and they wanted to pursue the main claim and did not provide consent for the sum claim. Now, like I said, I've only seen that one time in all the years I've been doing this. You will have permission to settle with the underlying carrier. You'll send them a release. You'll get the money. You'll file a demand for arbitration, and now you can pursue the SUM claim. So let me tell you about two cases that I've actually been involved in where SUM came into play. First case is I was representing a young woman who was riding a bicycle in Brooklyn who was struck by another vehicle. The other vehicle only had $100,000 in coverage. Her injuries were rather significant. She broke her leg, it required surgery, and clearly the damages she sustained exceeded the value of the policy limits of $100,000. We were able to get the other vehicle to tender its policy limits of $100,000. We got consent from her SUM carrier. She had $300,000 in SUM coverage available, and we pursued that claim. Once the SUM claim is filed, her insurance company is entitled to all the information that an adverse insurance company would be entitled to if we were pursuing the case in litigation. So we provide medical records, we provide medical record authorizations, we give them an opportunity to conduct an examination, we give them an opportunity to conduct what's called a deposition. We do this because insurance companies do not like to give out money. They don't just hand out money and say, here you go, you have the coverage, you're making a claim, we're gonna just pay you. That's not the way it works. They will fight you tooth and nail so they don't have to pay anything, let alone the full policy limits. And that's why it's important to have attorneys that know what they're doing, that will fight for you and that will fight back against the insurance companies and that will hit them hard to get you to maximum recovery, because they just don't pay this money out. So after we sent them everything, there was $300,000 available coverage. She already received $100,000 from the adverse vehicle. They eventually paid the $200,000 without us having to go to arbitration and having an arbitrator make the decision. Now, in the second case, my client was in a car accident. It was the other car's fault. His injuries were catastrophic. He had 2 broken legs, a broken arm. The surgery was required, and his injuries clearly exceeded the value of the $25,000 in insurance coverage that was available to him. He did not have SUM coverage. He had nothing. And so what we had to do is we had to unturn every stone to make sure that there were no assets available from the other driver and no additional insurance coverage was available from the other driver. How do we do this? We want to see who the driver was living with, if he was named as insured on any other vehicles, if anybody else in his household had insurance policies that may have covered him for this accident. And the reality is somebody who has only $25,000 in insurance coverage does not have assets to go after. So the likelihood of getting anything above the $25,000 is almost nothing. So he had to settle for the $25,000 in available coverage, and that was it. What's important to know about this is SUM claims are contractual claims because they are made against your own insurance policy, which is a contract. And in those policies, there is an arbitration clause stating that if you file a claim against the policy and you make an SUM claim, you have to proceed to arbitration. So there is really no option to litigate it. One of the scariest things I've learned over the years and continue to learn is that most people don't even know what SUM is. They don't know if they have it, they don't know if they don't have it, and they don't know really what it is or how to get it. So how do you know if you have it? You look at your insurance policy, you look at the first page, it's called the declaration page, which summarizes the available insurance coverage you have. And you look for the line that says Supplemental Uninsured Underinsured Motorist Coverage, or SUM, and you look what the policy limits are. And then you compare it to what your policy limits are. And I've seen this. If you have $100,000 in insurance coverage, you should have $100,000 in some coverage. I have seen policies where the policy limits are $100,000 for liability claims, but the sum coverage available is only $25,000, and that just doesn't make sense because the cost of getting the additional coverage is minimal compared to the benefit that it will provide you. It really is only a couple of dollars a month just to get an additional $75,000 in available coverage. And like I said, if you only have $25,000 in coverage, most likely you're never going to be able to use it anyway. So please make sure that if you have SUM coverage, you have the maximum amount available to you. Now, if you can't find your policy, or you can't find the declaration page, or you don't understand how to read the declaration page, call your broker. Call the person you obtained the policy from and ask, do I have supplemental uninsured, underinsured motorist coverage? Or just say, do I have SUM coverage available to me? And they will tell you. And if you don't have it available, you need to ask questions as to why it's not available and what you need to do to get it and what it will cost you. Then get the coverage. I can't stress enough that the value that this provides compared to the cost is astronomical. It's important to protect you, to protect your family, because there are many people driving in the state without insurance coverage or with very little insurance. And if you're in an accident through no fault of your own and your injuries are catastrophic or significant, you should be compensated as much as possible for your pain and suffering, for your lost time from work, for cost of medical expenses, for cost of future medical expenses, for future time lost from work. These are all big things that add up over the course of time in which you should be compensated for, especially if you had nothing to do with causing the accident. You are the victim and you need to be made whole. So when you're in an accident, don't forget, get a police report. Make sure the accident is documented. Take photographs of the accident scene or the property damage to your vehicle and the other vehicle if you're able to. Get medical treatment contemporaneously with the accident, because if you don't, you better believe the insurance company is going to say, if you have injuries, they're not related because you didn't get medical treatment right away. And consult with an attorney. Personal injury attorneys work on a contingency fee basis, which means we do not get paid unless there is a recovery. And there are hundreds and thousands of attorneys in New York State that will be more than happy to speak to you if you are in an accident to help you so they can get your case. Take advantage of that and don't pay an attorney to do your no-fault application, because that is one of the biggest scams I've seen. Make sure if you hire an attorney that does personal injury and is going to help you, they do the no-fault application and they don't charge you anything extra for it. There is no downside to have somebody on your side fighting the insurance company and protecting your rights. And it doesn't cost anything unless there is a recovery. So do it. Just do it. If you've been injured in a car accident, ring Rizzuto at 855-Rizzuto, because we can help and we won't charge you to fill out your no-fault application and walk you through the process and get your no-fault claim set up. And if you need information on no-fault and you have questions about what no-fault is, call us or watch my video on no-fault claims and how to win your no-fault claim. We represent clients all over Long Island, throughout all 5 boroughs of New York City, Westchester, and beyond. And if you like this video, you found this information helpful, like the video, subscribe to the channel, and I will see you next time.